Good morning and welcome to the Court of Appeals today. We have several matters on our calendar, beginning with the case of the estate of Carey versus Spencer. Counsel, if you would please enter your appearances for the record.
Cameron Sabin of Mayor Brown, LLP, on behalf of the appellants.
Brett Hastings on behalf of the estate of Doreen Jo Carey.
Perfect, thank you. And I am Judge Michelle Christensen Forrester, and I am joined on the panel today, as you can see, by my colleagues Judge Greg Orm and Judge John Luthi. Both sides have 15 minutes in which to make their arguments. I know you both have been here before, so you are familiar with our calendar and how everything works. It appears, Mr. Sabin, that you have reserved 3 minutes for rebuttal?
Correct.
The only reminder I will give you is to, because we are streaming, if you could please enter your appearance every time you take the podium, just so everybody's clear as to who is speaking.
Great.
Thank you.
You ready?
You may begin when you're ready.
Good morning, Your Honors. May it please the court. My name is Cameron Sabin. I'm from the law firm of Mayor Brown, LLP. On behalf of the appellants, T.R. Spencer and Associates and Terry Spencer. Mr. Spencer, through his firm, T.R. Spencer, represented the personal representative of the estate of Doreen Carey in his capacity as personal representative and in the administration of that estate. The estate lacked sufficient assets to pay Mr. Spencer's bills as they became due, and as a result, the personal representative, while acting as the personal representative, authorized an attorney's lien to be placed on some real property owned by the estate for the purposes of paying those fees when the assets were liquidated. There is an existing 2021 probate proceeding filed that is pending in front of Judge Pettit, and it concerns all estate-related matters, including the attorney's fees and costs that are owed to T.R. Spencer. On December 7th, 2022, Judge Pettit specifically ruled that the lien recorded by T.R. Spencer was not a wrongful lien. The court, then the estate, rather than addressing that issue on reconsideration or on appeal, filed a second or collateral case, making the very same arguments Judge Pettit had rejected. The court in the collateral case then, rather than dismissing the case or consolidating it, granted a motion for judgment on the pleadings ruling contrary to Judge Pettit's ruling. It is important to note that the posture of that ruling was on a motion for judgment on the pleadings. As a result, my client was supposed to have received all facts in his favor and all reasonable inferences in his favor. I will address today 5 different arguments. First, it is our view that the collateral court lacked subject matter jurisdiction over the wrongful lien issue because the estate brought the case and the estate is not a legal entity that can bring a case or seek redressability. Second, the collateral court should not have entertained issues litigated in the probate case because the probate court had exclusive jurisdiction over those issues as the case was first filed in the probate court. Third, in any event, the court in the collateral case misapplied the probate code and the wrongful lien statute in concluding that the PR lacked authority to allow a lien on the estate assets, and that counsel for the PR was not permitted to record an attorney's fee lien on the estate assets. And finally, go ahead.
You're going to get to it, I'm sure, but I do have a question about, we all know that an estate is not, it's an entity by virtue of the fact that it belongs to the, it's what's left after the decedent has passed away, right? And the decedent's assets. But Mr. Spencer acknowledged that he didn't represent the estate, that he personally represented Mr. Gibbons? Gibson? Gibbons. What do we make of that?
I don't think you make anything of that, and here's why. It is, I've done estate and trust representation for the majority of my career. It is the standard to represent the personal representative. And you will find that referenced all throughout the Utah Code, the Probate Code, and in the Utah Rules of Civil Procedure. For example, Rule 17 on the real party and interest requires that an estate be put forward by a PR. So you represent the PR, you don't represent the estate. That is the standard. And so what I think the district court...
The estate is not like a corporation. It's a separate legal entity, in other words.
Well, I think the estate is not a legal entity under Utah law. A corporation is, and if that's what you mean, then I agree with that. And for that reason, in one of the unique aspects of law throughout the country, in an estate and probate setting, the personal representative is in fact the estate. He represents all of the interests of the estate, and when you represent the personal representative, you're representing the interests of the estate. It would be unusual, Judge Forster, to have a situation where the engagement letter says, I represent the estate. Because then who represents the PR, and do you have two counsels representing effectively the same interest?
And so, given that, and given that sort of unique, I guess, legal relationship, in your opinion, is that why the probate court has exclusive jurisdiction over, the collateral court can't necessarily be involved in a situation that arises out of a probate action, right?
Right, I agree. And maybe I'll just skip to this part, but we have cited in our brief 5 or 6 probate statutes that specifically say that for purposes of a probate proceeding, the probate court addresses the question of what fees the PR should be paid, what fees a PR's attorney should be paid. There is a statute that makes it very clear that they're both entitled to receive compensation from the estate. So there is no question this is a probate issue that a probate court would normally address. And it is very unusual to circumvent that in the manner in which that happened in this case, because it effectively skirted what the probate court was already addressing. In fact, Judge Pettit is in the process of addressing our claim for what amount my client should be paid. He's still not been paid at all for anything out of the estate, because the argument is the estate assets are not reachable for that purpose, which I just fundamentally disagree with.
I mean, there are situations where, obviously, and we had that here, where a PR becomes adverse to maybe the beneficiaries or basically the beneficiaries. Can the PR become adverse to the estate itself?
Well, there's a mechanism for addressing that issue.
In 104,
And the
704 or whatever?
Yeah, the right mechanism is you can seek removal, or you can, or the court can directly address that matter through petitions filed in the probate court. That actually happened in this case. My client's position is entirely different. My client was the lawyer helping and assisting with the process of administering the estate and was not paid, fully paid for his services. So the question before you is just, should the collateral court have even taken this issue up in the first place? And our strong opinion is no. We had that issue, and it's currently being litigated in front of one court. It's bad policy of this state to have 2 district courts trying to address the same issue when the statute makes clear that the probate court has exclusive jurisdiction over those issues.
So Judge Pettit's order granting the motion for reconsideration and allowing us how she's going to now consider the attorney's fees, does that in essence moot this appeal? Or should we put it on hold pending, should we stay this appeal pending her further work in the probate case? What exactly is the posture of the current appeal given her order of January 22nd, in your view?
I do not believe you have jurisdiction in this case. I don't believe the district court had jurisdiction over this case. And for that purpose, Judge Orm, or to that point, I will read from you. This comes from a Supreme Court opinion that addressed an issue this court raised, and this is the Fauchot case. And this is on paragraphs 27 and 29 of that case. The court there said, quote, if the estate sought to advance this wrongful death claim, that was a wrongful death claim, in this case it's a claim of a different kind, It could be said that there was no cognizable injury asserted by the plaintiff, or alternatively, that any alleged injury is not redressable. And that sort of defect could present both procedural capacity problems and also a standing problem. We need not and do not resolve that question conclusively. We flag it as a potentially worthy of further attention in a case in which it's squarely presented. That's this case, where you have a party who is the estate, it's not a legal entity, trying to pursue a claim, and there's other problems with their claim, but in the first instance, Judge Orm, I don't think we ought to stay this. I don't think we have jurisdiction over it. I think it ought to be kicked out, and that we ought to leave it to Judge Pettit to address the issues that she had exclusive jurisdiction from the very get-go to address.
In that paragraph 26 that you just quoted, the Supreme Court, though, does recognize that there are two different types of issues that could be going on. One being whether the party has procedural capacity, and that being a procedural, potentially procedural defect, but not jurisdictional defect. But then the question of standing. And in this case, the reason why the court said that the estate did not have standing is that the estate was not injured by the wrongful death. Isn't that what it was saying?
I guess I read that differently. I don't think the Supreme Court, I think the Supreme Court was saying to you, because this court had ruled that it was a procedural issue under Rule 17. I think the Supreme Court was saying, no, no, no. If that were in fact the case presented, it is either a standing problem that's jurisdictional or a non-redressability issue, which is also jurisdictional. A party can't come before this court seeking relief if they are not a legal entity. Also, a party can't come forward if they don't have the legal capacity to even bring the case in the first place. So I read that differently, Judge.
What do you do with the last sentence of paragraph 26 then? And that sort of defect could present both a procedural capacity problem and also a standing question. It seems that the court's acknowledging a procedural capacity problem as a potential problem that is separate from a standing problem where you've received injury.
Well, what I do with that is, I do think it would be both, but I don't think they're saying it would be one or the other. I think they're saying if you have an estate, that is both a procedural problem, because under Rule 17, an estate is not the real party in interest. But that also.
But that's not, but I understand that if it's only that problem, that's not a jurisdictional problem.
Well, I don't know how to read it other than the Supreme Court said to this court, it's not just a Rule 17 problem, which is procedural. They said if this were the issue presented, which this case presents, that is more than just a Rule 17 problem. And I agree with that, and we've cited to you numerous cases around the country where the very thing that happened in this case has been these cases have been tossed out and said, you have to bring it in the right way, with the right party, with the right capacity. Otherwise, it's not legitimate.
For a moment, assume we have jurisdiction, and my question is on issue preclusion. Given where things are at in the probate case, has there been a final judgment on the merits of the wrongful lien issue?
Our view is yes, and here's why. In a probate setting, we file petitions. So the petition that was filed by the estate, or the PR of the estate and the family of the estate, they filed a petition. That petition raised one issue and one issue only, the question of whether this was a wrongful lien. Judge Pettit, in December of 2022, resolved that fully and finally, and that issue has not been litigated and won't be litigated again.
So what's going on now? The wrongful lien issue is passed and done, and whether it's a valid lien, and if so, because I think there's a difference between a valid versus invalid lien and a wrongful lien.
It should be noted, and maybe we might not have been clear, we actually removed the lien
That's right.
after this happened, for the reason that we didn't want the court to think we were flouting the district court for the.
That's right. So what's going on in the probate case is only having to do with dollar amounts.
Exactly.
Okay.
Exactly. She is now addressing our claim and the amount that we should be paid. It's no longer a question of whether the lien was wrongful or not.
Thank you.
My time
Thank you,
is up.
Mr. Saban.
Your Honors, may it please the court, Brett Hastings on behalf of the estate of Doreen Jo Carey. I want to focus, I will say from the beginning that we will ask the court to affirm in full Judge Faust's order. The lien was wrongful, there is jurisdiction, there is no issue preclusion in this matter, and the attorney lien was wrongful by the express analysis of the express language of the attorney lien fee, or the attorney
Judge
lien
Faust
statute.
is, if I'm recalling correctly, expressed some trepidation at the outset about whether he should be monkeying with this, given the pending probate proceeding. Do I have that right?
At the initial outset, there was some discussion about possibly transferring the case to Judge Pettit's court. Ultimately, the defendants never asked for that, and it was never transferred to the case. I do want to, and so there was some consideration, as we point out in our responsive brief. Judge Faust did not step on anyone's toes, violate comity, or violate the statute that provides exclusivity in the probate court, because the things that he litigated in his court were things outside of the probate code. We're talking about an analysis of the attorney lien statute. That is not inside the probate code. We are talking, it should also be remembered that at the time that it wasn't a petition, but I believe a motion in the probate court that was brought by the beneficiaries, not by the estate, because Mr. Gibbons was the PR at that time. It was only after Mr. Gibbons was removed for cause, a new PR was appointed, that PR elected to sue Terry Spencer and his law firm for three things. One, for malpractice, assuming that he was going to claim that he was the attorney for the estate. Number two, fraudulent billings, because many of the billings that we contend that he sought to collect from the estate were for things not related to the estate. In fact, were for Mr. Gibbons in his stance adverse to the estate or a non-party to something. And then finally, we did include the wrongful lien, because the wrongful lien had not been fully adjudicated below. It was outside the probate court. Now, I will point out, Judge Orm, that...
But how do you say that when Judge Pettit ruled that the lien wasn't wrongful?
Well, you have to
Are
understand...
you saying she didn't have jurisdiction to rule on that issue?
No, I think that she could have ruled, but there was no final judgment in order, and there was... I guess my point is this. The statute that provides for exclusivity clearly states that it's exclusivity for things within this chapter, meaning the probate code. So the estate elected to take those issues out of the probate because it wasn't a part of probate. Remember, within the probate code, there is a process in which an attorney who represents a PR can petition the court for fees, be awarded an amount, and then the estate is liable. That is the process. What an attorney that represents a PR can't do is just unilaterally file an attorney lien, avoid that whole process, and that was our entire objection.
Why is that? The attorney lien statute says that an attorney's lien commences at the time of employment of the attorney by the client, and then you can file a notice of that lien.
Right.
And so the amount of the lien may need to be litigated or determined and all of that, but the lien attaches as you begin work as an attorney.
That's true to the property of a client. But as Mr. Spencer admitted time and time again in his pleadings before Judge Faust, the estate was never his client.
What do you do with the statutory provisions that say that an attorney representing a PR can be paid from the estate?
The way we distinguish that is that they can then go through the process within the probate code to be awarded those fees. And we acknowledge that that's happening. I will point out that Judge Faust asked that very question when he was considering whether to take the case. He asked Mr. Spencer's counsel, has Mr. Spencer filed a petition to be awarded attorney fees? They admitted that they had not. His order said immediately do so. They didn't do that for almost 2 years more. They have done it now after the Faust case below was decided. They have now done that. And so I think what we see is a conflation of the process within probate to be awarded fees and the right under the attorney lien statute to file a lien. When we look at the express language in the attorney lien statute, it clearly states that that right extends only to the property of a client. Only to the property of a client. Mr. Spencer himself, it's uncontested, the estate
So-
was never his client.
So any attorney that does work for a personal representative, although they know they should be able to be paid from the estate, they never have a lien against the estate? Is that what you're asking us to hold?
Yeah, I would say
Because
that
the
the
estate
two,
is
there's a
never the
process
client.
within probate that should be filed. And then there's an attorney lien, the statute has expressed language that limits an attorney's ability to use that very powerful tool.
But just again, that sounds like this would be one narrow area where an attorney, for practical purposes, does not have a lien, have an ability to lien the entity that's benefiting from the attorney's work.
At least not under the attorney lien statute, that's our entire argument. Because the estate was not the client, the attorney lien right doesn't extend. That does not mean that the attorney for the PR does not have the ability to be paid. They can be paid through the process of filing a petition, proving that what they did benefited the estate, was not adverse to the estate, and then they can get a judgment or an order that says the estate must pay this. At that time, they could then place a lien on the estate's assets, not through the attorney lien statute, but by virtue of the court's order. And so that is, I think what we see, this is a good case to distinguish these two rights of getting paid and how you get paid. Because in this case, we had the very situation that can cause a problem. The PR acted adversely to the estate. The PR had to be removed for cause. And then the PR actually after his removal tried to approve an attorney lien on the assets of the estate, which is completely improper.
I have a question about issue preclusion and finality.
Yes.
Your position would be that Judge Pettit got the wrongful lien issue wrong. But is there any ongoing litigation on the wrongful lien issue in the probate matter? Why is that not its own proceeding that has concluded and we meet privity and same issue, wrongful lien, it was litigated, it's no longer being litigated and is final?
Well, I would just submit that there are three elements that have to be established for issue preclusion to extend. Number one, there has to be the identical issue, which arguably we have here, but that issue has to be fully litigated. It was not fully litigated. It was upon a motion, and it wasn't until the district court case before Judge Faust that we got discovery, admissions that the estate was never the client. So Judge Pettit didn't have that information. Secondly,
do you have a source that defines fully litigated to mean something less than?
well, that would be, I
full
don't have
briefing
a
on the
citation
issue?
for you today, but I would say that we don't need to rely on that, even if we concede that the issue was identical. The parties were not identical and there's no final judgment and order on that issue. It should be remembered that the objection brought in the probate court was brought not by the estate, it was brought by the beneficiaries of the estate. The case before Judge Faust was brought by the PR of the new PR on behalf of the estate. So there was not the identical.
Is there privity, isn't there privity though between a PR and an estate?
I would, well, a PR is a fiduciary. By statute, a PR is a fiduciary of the estate with the obligation to act on behalf of the estate. But again, we're not talking about identical, we're not talking about the estate challenging in the probate court. It was the heirs.
So is there privity between the heirs and the estate?
No, I would say that there is no privity between the heirs and the estate, and especially no privity between representation of a PR and the heirs, as demonstrated here. I think it might be important to point out, and you know, as I shepherdized cases prior to oral argument today, I did come across a case that I think is very important. It's the Goldberg case, and it's a case in which, I can give you the citation, but it's a case in which the court clearly, I believe it's the Utah Supreme Court, no, or it was this court, said that an attorney for a PR does not represent the estate. And I think that's very important to note here, because there seems to be a conflation of, well, because Mr. Spencer represented the PR, he then by extension represented the estate and therefore had the ability to put the attorney lien fee on. Again, the attorney lien fee, the attorney lien extends only to the property of a client. Mr. Spencer says the estate was never my client. So under that prong, the attorney lien would not be appropriate. If we turn to the statute that defines what an improper deed is, or improper lien is, there's three things, three exceptions. A wrongful lien, this is found in Utah Code 389102, 12A. Wrongful lien means any document that purports to create a lien, notice of interest, or encumbrance on an owner's interest in certain real property at the time it is recorded is not, sub I, expressly authorized by this chapter or another state or federal statute. So we would argue that by the express language of the attorney lien statute, that it was improper. It's not authorized by that statute to put a lien on estate property when the estate, admittedly, is not your client. I think I counted up 20 plus times within the attorney lien statute where it says it applies to the property of a client, to the client. And Mr. Spencer acknowledges that the estate was not his client. Secondly, was there a court order? There's not a court order to allow a lien to go on. In fact, Mr. Spencer has not even gone through the process here years later to even get an order from Judge Pettit to say he's owed anything. So there's no underlying debt. And then the final issue, which they...
Well, but she still has that under, she has that under further consideration, does she not?
She
Per
does.
the January 22 order.
She does, but without any kind of order saying, Mr. Spencer, you're owed something, it naturally follows that you can't put an attorney lien on when there is no underlying debt.
So, if nothing else, the attorney's lien is premature.
Well, I would suggest it's entirely wrong. He may have a right to lien after he gets awarded fees. He doesn't have a right to put an attorney lien. So it's the distinction between a general lien pursuant to a court order and an attorney lien. An attorney lien is a very specific statutory right that an attorney has. It's very powerful and therefore must be limited in its use based on the express language of that statute. It's very clear. It requires it to be a client. I do want to, I'm sorry, my time is running. I want to just maybe reserve 1 minute, but the third exception is if it's pursuant to signed authorization signed by the owner of the real property. There is nothing like that here. Now, Mr. Spencer, interestingly enough, presented in the district court case a document that was signed by Mr. Gibbons purporting to authorize the attorney lien. The problem with that is Mr. Gibbons was removed on the 9th of September, and he signed that amendment or that agreement on the 16th of September. So that cannot authorize. Mr. Gibbons had been removed, had no authorization to approve anything. And so I would simply say, Your Honors, that there was jurisdiction, there was no violation of exclusivity in the probate course because the matters that were litigated are outside the probate case. It's very important that we distinguish the attorney lien statute right with just the probate process and a lien that arises out of a court order once an attorney for a PR has been awarded fees. And we'd ask that the court affirm on that basis.
Can you give us the site to that Goldberg case? that
Yes,
you
absolutely.
mentioned?
Thank you. Oh, it does look like it was a Supreme Court case, I'm sorry, in regard to the estate of Goldberg, 2024 UT 15. And if you'd like, I could give you a very brief, okay, thank you.
That's good, thank you. Mr. Saban?
I'm looking at, this is record page 105. This is the docket from Judge Pettit's court. This is the entry on December 7th, 2022. The court provides its ruling on the petition to nullify attorney's lien as set forth on the record. The petition is denied. So it's not a motion, it was a petition, it was fully resolved. There wasn't any need to address it any further because she fully resolved their petition, which was seeking exactly the same relief that was being sought in front of Judge Faust.
What's
Second
your
point.
response on the
Yeah.
issue of privity of parties? Do we have the same parties or privity?
I think it's
Parties and
really,
privity?
I would encourage you, Judge, to look at their briefing, because on the section on jurisdiction, they say, oh, no. It was the PR, it was the PR, which it never was. But then when they get to this issue of privity, they say, oh, no, the estate was the party. And the beneficiaries of the estate are interested parties of the estate, but they don't represent the estate. Well, somebody has to have the interests of the estate at heart. If you're claiming as an interested party, a beneficiary, that something should be done on behalf of the estate, you're acting in privity with the interests of the estate, or at least you're purporting to do that. So I don't think you can have it both ways. I think you have to pick your poison. They're not, because it hurts their case. As to the question of, the lien was filed in June of 2022, before any removal occurred. He's misquoting the record. June of 2022, it was amended later, but it was recorded in June of 2022. This issue was argued in front of Judge Pettit. Judge Pettit said, not a wrongful lien. She went through all the facts, which you don't have all before you, but she went through all the facts and said it's not a wrongful lien. So why are we having Judge Faust take a recut at that? That makes zero sense here. As to the attorney fee statute itself, I think what I'm hearing is that in estate-related matters, an attorney can never have an attorney's lien, because either you would have to have an engagement letter that says, I represent the estate and have the right to lien the property of the estate, which creates a problem because the estate's not a legal entity, or I represent the PR and I just don't have the opportunity. I think he's reading the attorney lien statute too narrowly. There's no carve-out in that statute for except probate cases.
He is reading it literally, though, where it does say an attorney's lien commences at the time of employment of the attorney by the client.
Correct.
And if the estate was never the client, how does that language get triggered?
Well, we point out in our briefing that when a PR becomes appointed, all of the assets of the estate are titled in the name of the PR. The PR becomes the owner of those assets. And so it is.
The assets are there to be liened, but the statute doesn't seem to get triggered if you read it literally, because you're not representing the estate.
And I would tell you, Judge Luthi, I agree with you that on the face of the statute, but that interpretation can't be what the legislature intended, because they didn't provide an express carve-out to say, well, except in the following cases, where there is this weird situation where the client is a non-existent entity and we have a representative of that entity. There is no. It
sounds like an absurd results.
It does to me. It feels to me like if they intended that, they would have circumstance more than any other circumstance. Who would in their right mind represent a personal representative if they knew going in, I don't have relief if I'm not paid?
But you do have a relief if you're not paid, and that is by filing the petition in the probate court, right?
Except that, remember, Judge, a lien, the purpose of a lien is to stop the transfer of assets. It's to prevent something from happening that I can't undo. If I don't have the opportunity to do a lien, then like this circumstance is perfect. My client's left hanging with no payment. A new PR is appointed who then challenges and doesn't make the payment and goes to try and liquidate assets. I am left high and dry without that as an opportunity. There isn't a solution for that in the probate code. There is a solution for getting the court to address how much I'm owed, but there isn't an obvious solution that the lien statute provides. Does that make sense? I think my time is up. Thank you very much.
Thank you both for your arguments today. They're very helpful. We will take this matter under advisement and render a written decision just as soon as we are able.
Thank you. Thank you very much.
Thank you.